Hey, yo, folks! It is time for an update in the YNW Mellys case. His ex-girlfriend had a hearing where she wanted to get rid of the ankle bracelet. Let's see how it went. Welcome to the show. All right, let's see how it went.
Yeah, so you ready for me to go back on with you? Ready, sir?
Yes, Your Honor.
Okay. Your client is present?
Yes.
Miss Hampton, where you at? Yeah, come on up. All right, Mike, you good?
Yes.
Okay, let me go back on the record. This is actually on the topic of the case turned out of state versus Jamel Devins, 19-1872 CF10A. The reason that we're here today, this is an emergency motion to vacate, which is filed on behalf of Mariah Hamilton, who is a material witness in the case. Can I get the lawyers to announce their appearances for the record?
Yes, Christopher Barris for Ms. Hamilton.
Justin Griffiths, on behalf of the state, and joining us on Zoom are Ms. Buckaloo and Ms. Collins.
Okay, a little background here. Miss Hamilton went abroad, allegedly to avoid having to testify. Then first trial happened, and then, what was it, a month ago, she suddenly decided to come back, and she was promptly arrested on the airport, then put in an ankle bracelet because, well, the prosecutors don't want her to disappear again. Now, this is the hearing regarding if this was actually within the boundaries of the warrant, I believe.
All right, I got them both on the same call. So, counsel, I did read the emergency motion to vacate, which was electronically filed February 17th. I likewise read the statutes and the authorities cited therein. So, any evidence, witnesses, or testimony that you'd like to present? Please.
Not at this time.
Just your argument?
I think the court can decide based on my pleading.
So, Mr. Griffiths, let me ask you, since you're the one that's here, the state's position on the defense emergency motion to vacate, they want me to take the ankle monitor off this one.
No, Judge, they would be objecting based upon the fact that the writ was issued in the first place and the difficulties in securing her presence for trial.
Okay, so listen, again, not that I'm certainly not foreclosed to reconsidering this at a later point in time. And for the record, I did read the motion, and there's a lot in here about 942.03. Mr. Barris's position is that that's not applicable to Ms. Hamilton, and he's probably right about that. That's why I released her from custody the first time that I saw her. However, I did look at everything in the electronic docket. I was not the trial judge back then handling this case. I'm not making any judgments or finding any facts about it. But there does seem to be an awful lot of pleadings, emails, letters, pleadings, notices, that there were some issues going on about cooperation with witnesses. So there's an easy way to do this, and there's a hard way to do it. It would appear the prior judges that handled this case came to the conclusion Ms. Hamilton chose a hard way to do this thing. I don't think anyone that's not charged with a crime should be under any form of security anyway under normal conditions. However, this isn't a normal condition. The state's identified her as a material witness. I do have 902.15. Again, this is only applicable when someone is facing life imprisonment or the death penalty. Mr. Devins is in fact facing the death penalty. All she, just like any other witness, has to do is come to court, and either side wants them to come to court to a deposition, to a motion, or to a hearing. And as soon as that responsibility is concluded, that will end the security that's been put in place, which I have chosen to be an ankle monitor as opposed to proposing some form of monetary bond. So at this point, respectfully, I'm going to deny the emergency motion to vacate. It's going to stay right the way it is. And again, I'm not foreclosing either side filing whatever motion in the future. If you want to need time for an evidentiary hearing, I'm happy to do that. And again, I'm always ready, willing, and able to listen to any evidence, witnesses, or testimony that either side wants to present regarding the issue, but based only on what I've read in the electronic docket and what's been in the pleadings, because that's the only thing that's been presented to me. I'm just not comfortable doing anything else at this time. So that's what it is.
Your Honor, I don't understand where you're deriving your authority from. Can you explain that for the record?
Well, I mean, actually, I usually don't have to answer lawyers' questions, but this is security. The security is the ankle monitor. I mean, the alternative would be, do you want me to take the ankle monitor off, put her back in jail, and set a monetary bond for her to post? Is that what you want me to do? So that's what security means in the statute, just like any other bond statute. So That's where I'm getting the authority from, sir, 902.15. So I'll enter the appropriate written order. Again, Ms. Hamilton, same as when I met you before for the first time. If any side subpoenas you to testify at a deposition, at a hearing, or a trial, whoever that may be, state or defense, all you gotta do is show up, honor the subpoena, and then as soon as the trial is over and the matter is resolved, we will also resolve your current situation. Anything else I can do for you this morning?
No, Your Honor.
State, anything else I can do for you?
No.
Okay. So, Mr. Devens, all pending motions remain set April the 1st at 1:45 p.m. His trial remains set September the 10th at 9 o'clock.
It seems like the judge isn't budging on Miss Hamilton being on an ankle monitor. As he stated, she is, according to the prosecution, a material witness. And who has, according to the prior judge, not being available for testimony. She went abroad, and now she's back, and they don't want her to be abroad anymore or go abroad anymore. It's not that much her lawyer can do about those simple facts. Now, I know there are a lot in the details about if she's really a material witness, if the warrant was as accurate as it should be. But in front of this judge, he just want her available if they subpoena her for testimony.
So I believe that concludes FT for this morning. However, we are going to handle one matter on the FG docket, which is State versus Willie Ward, 15-10015 CF10A. So as soon as I have him present, and I have all the parties present for that, we'll go back on the record. So we're going to be in a recess until we're ready to go forward with that.
All right. Is it anything else with Miss Hamilton? I do not. Then it moves on to another case, it seems. And that's not what we are here for. And so whoever this gentleman in the prison stripes is, good luck to you, but not a part of the case I cover. So, yeah. Easy to understand the judge's position here. She is a material witness for the prosecution. Now, I know prosecution and all its shenanigans. I have doubts about the validity of how they act. But for this judge, the statutes are on his side. And so Miss Hamilton will be in ankle monitor until the trial is over. So short update, Miss Hamilton still on ankle bracelet. So everybody, thank you for tuning in. Until the next stream or video, have a good one. See you. Bye-bye.